Good afternoon, and thank you for joining us today. I would like to welcome you to the fourth and final part of FortneyScott's Workplace Legal Compliance webinar series entitled Planning Your 2026 Workplace Compliance Priorities. This webinar will be recorded. Today's presenters are FortneyScott attorneys David Fortney, Nita Beecher, and Bert Fishman. I will now turn the program over to David to start the webinar.
Thank you, Sarah, and welcome everyone. I'm just so glad to be here with Nita and Bert in the office, and we really, I think this is the perfect way to end up what I hope you found. We certainly have enjoyed this four-part compliance series, and it really reflects so much of what we're hearing from our clients as they look over the horizon into Q1 and Q2 of 2026 and beyond. And are really sort of wondering at what is, I think, one of the most chaotic years that any of us have ever experienced in Washington as far as what they should do. And that's really what we want to focus on, is kind of not sum up briefly, but really to more start to pivot and really looking forward, because I think that's what most people are doing. Let me just take a moment and just a word or two basics. I think that at this point, most everyone is familiar with us, but we are, of course, Washington, D.C. firm. Our practice is focused exclusively on dealing with the federal agencies, principally, and the federal related developments, all of which we're going to be talking about today, and the major agencies governing the workplace, and some that aren't necessarily major agencies, but that impact the workplace. And all of us, and certainly the three of us and our colleagues here at the firm, all have very significant experience in dealing with a wide range of these matters. So let's turn to, and we talk about these on podcasts as well, and that DC Insider podcast, and the three of us do that quite often too. It's a good source. Here's what we want to run today, though. We want to talk a little bit as we look forward about the EEOC, obviously some significant changes there. The DOL, kind of where we are and where we're going. The Labor Board, which continues this 9-10 months kind of lost opportunity, but that's about to change. The Justice Department, a very significant component for any employer who's well counted on compliance, and really then spend the last part unpacking those practical steps that so many of our clients I know are interested in. So why don't we jump right into EEOC? And Nita, would you like to jump into that for us?
I would love to. So let's go to the next slide and just talk about where we are. We now have 3 commissioners. And why is that important? Because to have a quorum for the EEOC to do anything, you need 3 commissioners. And in addition, we now have Andrea Lucas, as you all know, has become the chair, not the acting chair. And Brittany Panuccio was sworn in October of this year. And Kalpana Kotegal is the only remaining Democratic commissioner remaining after Trump fired the former chair and vice chair, as he did with many other of the independent agencies. What's going to be interesting is, and as well as the general counsel, which we'll talk about her in just a minute. So meanwhile, we're going to talk a little bit about Trump versus Slaughter. I think Bert's going to talk about that in a little bit. That will impact whether or not the Democrats who were fired by Trump have any chance whatsoever of coming back. I think the answer is no. But one of the interesting things that I just wanted to mention is that every time she speaks, Chair Lucas, and David, you're going to talk a little bit about your conversation with her. She usually starts off by saying that she believes that the EEOC is an executive branch agency. Right. Many people believe that if it wasn't an independent agency, EEOC was at least quasi-independent. So, David, let's talk. You want to talk a little bit about your discussion with the chair?
Sure. I had the privilege of meeting with Chair Lucas for a podcast. It runs about 55 minutes. And she's pretty, one thing about Andrea, she's transparent about what her beliefs are. She's confident. That is helpful from a compliance standpoint, understanding where she's coming from. I know that Commissioner Kotegal has recently said, well, those were her as acting chair, and that wasn't the full vote of the commission. With all due respect to the commissioner, I think that there's no doubt that the Republican majority will ratify, build on, and continue everything you saw from acting chair Lucas when she didn't have a quorum, number one. Number two, Andrea does have a bit of a long memory, and many employers, we're going to talk about some of the DEI pivots, but certainly Chair Lucas is acutely aware that employers prior to the Trump administration may engage in some DEI programs that she believes were problematic. There's some interesting legal issues there in terms of the statute of limitations and how those may work, but nonetheless, I think that she's made her priorities clear, and we can talk about that a little bit. But I think the podcast, not shameless self-promotion, but the substance is great that she put on there. So check it out. Yeah.
Nina, can I just ask one?
Sure.
Commissioner Codigal recently has been very outspoken in her criticism of the EEOC and of the administration. And there are, I don't know whether they're rumors or whether they're thoughts that either she may resign to keep them from being a quorum, or she's looking to get fired. What do you think?
Well, we'll have to wait and see. According to what we understand from insiders, that up to this point, Commissioner Codigal has been fairly careful about what she said, but in recent comments, she has not been. She has been blasting him with both barrels, as we would say.
Mm-hmm.
So I think, it's a possibility they could decide to fire her, but that would not be in their interest. She might decide to quit.
At an opportune time.
At an opportune time, just as they're getting ready to make some of the changes that we're going to talk about in a minute. So one other thing I wanted to mention, and David, I think you had a little bit of a discussion about, so let's go to the next slide. One of the things we hadn't seen is a nomination for general counsel. The former general counsel, Carla Gilbride, was fired at the same time as the other two Democratic EEOC commissioners. So it's been open. There's been acting. Andy Rogers, who had been acting, just moved to wage and hour, which David, you'll talk about in a minute. But now they've nominated M. Carter Crow, who's in Houston at the Norton Rose firm. At the present time, he's head of their global labor and employment group. But David, what I found interesting is I don't see him doing a lot of EEOC work. Am I wrong about that?
No, his track record is mostly wage hour. It is systemic, although let's face it, the general counsel isn't directly litigating, not a position that's in the trenches, but someone who certainly understands larger systemic cases. Strong resume, has been the president of the Houston Bar Association and so forth. But the nomination process really is just beginning on Mr. Crow. Barring something unexpected, I believe he will be confirmed.
Absolutely.
I think it's just a question of when, and we see some of the dysfunctionalities of the Senate. So I don't know. I have no prediction on that process or when that will occur. But I think, he'll be fine. I mean, we have a rich history. The last two presidents have both fired the general counsel of the NLRB at the commencement of their term, put new ones in. That happened with President Trump. It happened with his predecessor. So it will continue.
Okay, so let's talk about the enforcement priorities, and both of you all can jump in, but let's kind of walk through those. So none of this is new because Lucas has been very transparent, literally from day one. And so DE&I, especially race discrimination, I think less sex than race. Clearly, religious bias and harassment, we've already seen that with anti-Semitism. So I think DE&I is going to be very much against corporations. I think anti-Semitism so far has been very much against higher ed and all the things that happened on the campuses. A new one, and I would like both of you to talk a little bit about this, anti-American national origin discrimination. Not very surprising considering the position of this administration, but a little surprising for EEOC. And obviously, we know there'll be changes to the harassment guidance and the Pregnant Worker Fairness Act regulations. But I'd like to back up just for a second. So what do you all think about this? So they issued, which we'll talk about in a minute, national origin discrimination guidelines. And what did you think about that?
Well, let me just chime in. This is such a radical change for the history of the EEOC, which has from its very origins been concerned with America's historic problem of race. But this kind of mid-river shift is feeding the Trump base, and it's doing so quite successfully.
Yeah, I mean, this national origin, the H-2Bs, kind of the whole visa-related issues that have now gained steam. We have Operation Firewall that has been announced. Really, the Labor Department has a big component on that. It does represent. I mean, I think it's interesting and a good example of this unified executive branch.
Exactly.
That we have EEOC with their national origin. We would think of this as Title VII national origin discrimination.
Correct.
But it's cognizable. The Labor Department has questions as to whether certifications made for H-2B visas were accurate or deprived American workers of opportunities. The Justice Department has a piece of that. I mean, that's a significant initiative. It certainly has many of our clients, and there are many open investigations based on published reports of that. So,
well, let's go to the next one, because that ties into what they've been doing since the shutdown occurred, and they have issued this guidance around the anti-American bias, along with partnership with DOL. And I thought a couple of really interesting things. It's a one-pager on their website, and what she talks about there is that H-1Bs, that they're looking at whether or not people who are advertisements have that it's H-1B preferred, or that these are H-1B jobs, that kind of thing. And one of the important things, I think, and David and Bert, what you thoughts on this are as well, you can't make the excuse as an employer that Americans are more expensive, or that foreigners perform better than Americans. Those, they're making points that you can't work it from that way. And I find this very odd, considering that H-1Bs, I've done them many years ago, but you have to go to the Department of Labor. You have to fill out all these forms. You have to say, put an advertisement out and say there's no Americans who could do this job, and nobody responds. And so what is going on with this whole anti-American push here?
One of the things that strikes me is that this is one of the internal contradictions of the policies of the administration, with its support of an expansive tech sector, which is quite openly reliant on H-1Bs.
Right.
And now this very stringent, one might almost say nationalistic policies that are driving the EEOC on this issue. And they are going to have to come a cropper. They both cannot exist in the same universe.
Well, this is but the most recent example of the administration, from an enforcement standpoint, trying to look backwards and to take actions that people had understood were legal when they were conducted and were approved, and to challenge whether they were, whether it's how DEI programs are operated as federal contractors, whether it's the H-1B, the reps and warranties that are made under subject to the penalties of perjury. And of course, the go forward is that H-1Bs will be much more restricted. This is the $100,000 concept, the new user fee, to call it generically what it's called. And so, but I think it does represent there are these tensions. I don't know if there aren't Americans for these H-1B jobs. We'll find out, I guess, what the marketplace tells us. Historically, the answer was there were not Americans.
Correct.
That's why H-1B folks were eligible to be hired and were hired on that basis. But I find interesting that the administration simultaneously, we're changing the rules going forward. We're restricting H-1Bs, and we're going to have a big user fee, and we're going to re-examine what happened in the past. Kind of like the former OFCCP director, who, by the way, is currently the acting general counsel, the number 2 at the EEOC, said she was going to conduct forensic examinations of federal contractors and their OFCCP compliance efforts in the past. So there's a lot of looking backwards and second guessing in meaningful enforcement.
Well, let's take that the next step.
Yeah.
Subpoena enforcement actions. So not quite yet, Sarah. Thank you. We'll get to that in a minute. So they've also filed, since the shutdown, 2 subpoena enforcement actions, which I think are very important for people to keep an eye on. The first one is against UPenn, alleging their stonewalling on anti-Semitism investigation. This was based on a commissioner's charge filed in December of 2023 by Lucas, and saying that the university subjected faculty and staff to anti-Semitic harassment and failed to address, and so forth and so on. They've issued a subpoena to UPenn saying they want identification of witnesses and victims and so forth. And the university is saying, I don't think so because of privacy rights. So I will just tell you that I've been in an EEOC subpoena enforcement action. You do not want to be there. I'm just telling you.
Well, and I think this focus on expanding into the subpoena power, I want to draw people's attention as we think about this to the Columbia University settlement, $221 million, if I'm remembering the number correctly.
Yep.
$21 million was a victims fund under Title VII. That was the EEOC's piece of that. The higher ed points, as has been the case for the last 12 months, are illustrative of the playbook that we are also starting to see run on the non-higher ed, the rest of the private sector employers, specifically by EEOC. So I think that's one very important takeaway. These issues and the agency's response is not unique to higher ed. We are seeing it. We have clients that are under these very significant investigations and audits by EEOC that are starting to mimic these same playbook that we have seen over the last 8 to 10 months, focusing on higher ed. It's not limited to higher ed.
Well, let's take the subpoena enforcement action to the other side, which is DE&I. So you've got Northwestern Mutual, who is has a subpoena enforcement action because they won't bring forward certain people to be interviewed by EEOC. So we'll have to wait and see. But this is something very important and very something that employers need to stay on top of. One last thing I wanted to mention is just disparate impact. We know that Trump has issued an executive order against disparate impacts use. And in Title VII, just so everybody is on the same page, the disparate impact theory prohibits employers from using a facially neutral employment practice that has an unjustified adverse impact on members of a protected class. Facially neutral is one that does not appear to be discriminatory on its face, rather is discriminatory in application or effect. But an employer can demonstrate that if an employer can demonstrate that the policy or practice has a relationship to the job, then you have a defense under business necessity. And so they have dismissed all of the charges that are solely based on disparate impact.
This is fascinating because disparate impact under Title VII is statutory. And, it can't be dismissed with an executive order. So what's really going on now, and it's quite a radical change, is that the EEOC, by exercise of what I can call a prosecutorial discretion, is going to stop pursuing disparate impact cases under Title VII. And I think they'll be challenged because, as I say, the statute includes that as an appropriate means of curing discrimination. And I think there will be private parties seeking disparate impact claims despite the EEOC.
Absolutely.
I agree with that. And I think there's a rise in interest in state law claims and state law impact protection. So we're not out of the woods. And although EEOC's investigation may be perfunctory or effectively non-existent, they still will issue right to sue letters, and an individual still has the private cause of action under the statute, as Bert points out. So although the administration, whether it's in Title VII for employment, Title VI for higher ed, the Justice Department has walked back a lot of the public sector consent decrees that were based on impact, historical decrees. That doesn't mean this legal obligation, the statute exists, the state laws exist, and so we believe employers need to continue to be mindful of impact.
So let's go to the next slide. We've talked mostly about these, but just want to make a quick, be super responsive to the complaints to avoid subpoena enforcement. You need to train management and HR on these new DEI requirements. This is not just changing the name. This is really potentially looking at everything and ensuring that you're not making decisions of any kind based on protected categories. They all need to be merit-based and non-discriminatory towards any group. What we don't know at this point is whether EEOC will do as Project 2025 wants them to, which is eliminate the EEO1 report. They certainly won't do it this year, but they might do it for years after that.
Yeah, I think for employer planning for 2026, you're going to file EEO1s for sure.
Correct.
And interestingly, the administration is looking to actually expand IPED reporting for higher ed for student admissions and other things. So although they're wavering a little on whether to cut back on collected data with respect to workforce issues, with respect to student admissions, they're actually doubling down and expanding at the same time.
I think that's indicative of what really has become a war against higher ed, because throughout the administration, they have been eliminating data collection in a variety of different and unrelated areas. It's almost a theory that they don't want the government to collect data.
Right. But
except when they want to take out somebody.
Yeah, well, certainly, I just want to say, and we'll talk about this a little more at the end, but increasingly we have clients saying, well, should I still collect data voluntarily? And I want to be clear on this. Our answer is yes, it matters a great deal what you do with the data, who has access to the data. We'll unpack that a little later. I just want to put a pin in that. Whatever happens to these mandatory government reporting and effectively data collection, voluntary data collection still is permitted and often is very prudent to do if it's done correctly.
So one last slide really quickly. Just wanted to point out that this is really important. Lucas is not going to let companies memory hold DE&I violations. Just keep that in mind. And that's why David was talking about going back retroactively, like we were just talking about the Northwestern Mutual subpoena. And I think with that, David, I think it's time to turn to DOL.
Yeah, sure. Happy to. And I would just say that this from 20 to 24, as I've told the EEOC in more than one investigation, somehow my copy of the statute of limitations doesn't suggest that you should be looking at data from 2020 as effectively in 2026, but nonetheless they do. All right. DOL. They've had 10 months of activity, 10, 11 months now. And of course, although we had the secretary and deputy secretary, DeRemmer is Secretary DeRemmer, and of course, Deputy Secretary Keith Sonderling have been there. Effectively, the key agency teams have been slow to come. And that's not through any lack of interest or effort on the administration's part. I mean, honestly, I'm going to put that on the Senate. But it was during the shutdown that the key folks were onboarded. And so we have a solicitor, we have John Barry, probably best known outside being a Boyd and Grace firm, Supreme Court clerk, a lot of other very strong background points. Also was the author of Chapter 18 in the Heritage Foundation playbook that the administration largely seems to be running. Andy Rogers, Anita mentioned he formerly was he did serve in wage hour in Trump 1.0. He's come back now to head the agency. He had been Andrea Lucas's personal counsel for a period, then was the acting general counsel for 6-8 months at the EEOC, and is now running wage hour and is very strongly qualified. Ashley Romanius at directing OFCCP. That's the second OFC director we've had in Trump 2.0. Pretty low profile at this point, and we'll talk briefly about what's going to happen to OFCCP as this administration rolls on. Mr. Keeling running OSHA, very well qualified, very experienced, deep experience, well respected. The ODEP, I want to also call out Janet Dillon. Many in the EEOC community will recall she's the former chair of the EEOC, very deeply involved with this administration, particularly with the labor agencies, very well respected. And PBGC is a powerhouse, and you're starting to see lots of significant developments about how pension funds should be invested. Are social investments correct? Is that breach of fiduciary duty? There's going to be a lot of very significant developments, real money at play there too.
I also think it's important to recognize that all of these appointees are confirmed conservatives and staunch members of the Trump team.
Yes.
So we have a unified executive showing itself at the DOL as well.
And very well qualified. These are not mercy appointments.
Right.
Well, let's just talk briefly about wage hour. Andy Rogers is going to be running that, as we noted. What's he going to do? They're still working on finalizing their reg agenda, firming that up. But I think the playbook's pretty clear. The independent contractor regs and joint employment regs, we're going to go back to Trump 1.0.
Mm-hmm.
That at the end of the day is what the play is, and that's very favorable for employers. Okay, it makes the test clearer, makes it more aligned with business realities, and is positive. Second, Wage Hour Division has championed historically issuing opinion letters. That tends to be more of a Republican administration. It's a philosophy. If you tell people what to do, that will promote compliance, backed up with strong enforcement. The opinion letter process is robust. There's some real benefits under the Fair Labor Standards Act. It actually gives you a legal safe harbor, part of a broader opinion letter approach that the Labor Department is taking. I just would note in some states, if you make adjustments voluntarily under FLSA, under the Labor Department's blessing, you potentially could trigger state law obligations. So please make sure you have the appropriate advice on that. The paid program is basically this self-audit program I just mentioned, whereby you go through where people paid correctly to get overtime correctly, where they classified correctly, and make adjustments and get the Labor Department to bless it. The white collar rules, I don't know if it's going to be before the midterms or not, but that the white collar regulation has been the bane. Every administration that's tried to mess with it, usually it takes them 3.5+ years. They do something at the midnight hour, and it gets set aside immediately. So I don't know whether they will or won't try to update that at this point.
Let me put in my oar on the opinion letters. Valuable in themselves, and also create an opportunity for employers to get their opinions to the Labor Department. It's a two-way street. The mere application for an opinion letter is a positive for an employer being able to participate in this process, and very valuable and appreciated by the department.
Well, and we are currently involved in several very significant requests. We've enjoyed very good success with securing opinion letters, including when Mr. Sonderling was running Wage Hour and Trump 1.0 and others. So I will just underscore this administration is very interested in opinion letters, and that's something we found a strong interest in. Well, let's talk about OFC. Anita, do you want to talk about this a little bit? Because
sure. OFCCP,
what's going on?
We have no earthly idea. Okay? We have no earthly idea what's going on. So just so everybody knows, and it's important to keep this in mind, all of our workforce enforcement agencies are only funded through the end of January. So, but OFCCP is funded at Biden levels. So for maybe half of they have like maybe 250, maybe 300 employees as opposed to 550. They're still at $105 million. So we don't know what they're doing. But anyway, so you have that. They had put out, when Catherine Oshbach was the director, massive changes to Section 503, to which they got very negative response. 90% of the letters said, why are you doing this? We really like this. So we still have not heard what is going to happen going forward. But it appears that OFCCP is going to keep 503 and VEVRA. Initially, as we know, 503 was going to go to EEOC, but that requires Congress, which, as we can see, would take a lot to get that done. And that VEVRA would go to vets, but they don't really have anything in place to do that. But we still don't know what's going to happen. So I will say the Institute is trying to follow up with DOL and make sure that they understand that the contractor community is not interested in making these massive changes to 503. So anything else, David? That's pretty much what we know.
I mean, honestly, if any agency I thought would have been wiped out by DOGE, it was OFCCP. And boy, this just seems to just have 1,000 lives. OFCCP manages to zig and zag. And you mentioned about the funding. I saw this funding proposal that received bipartisan support in the Senate Appropriations Committee. So I reached out to some of the civil rights leaders, kind of the usual suspects, former EEOC commissioners and so forth, if you will, on the other side of the aisle. And I'm like, wow, you guys really pulled that off, kudos. They claim they didn't have anything to do with it either. I can't figure out where the energy is coming from totally on that either, but it's interesting nonetheless.
I happen to know Congressman Harris Falwell
Yes.
of Illinois, who invented Falwell's Law.
Yes.
Falwell's Law of Immortality is what.
Correct.
The way to stay immortal is to become a congressional or governmental program.
Yeah.
And the OFCCP is certainly
Chapter 1.
Exhibit number 1.
It's in the dictionary.
Well, let's unpack quickly then for the folks with respect to the Labor Department key issues. Certainly the use of the wage hour program, I think that's the one that most commonly, and for example, the last week, there were 4 OSHA opinion letters. So this opinion letter process we talked about and working collaboratively for some level of self-audits, and you're not going to get dinged or rung up on violations, is a wage hour program. OSHA is increasingly leaning into similar programs. Some of the other enforcement agencies, that is a strong directional approach that the department is taking. Wage hour, I think, is the lead in that, and the paid program we've touched on. Yes, Tina.
I was going to mention that when Catherine Oshbach spoke at the SHRM conference, she mentioned that OFCCP was looking at a self-audit program. So that might be because that would allow them to put onto the employers perhaps part of the certification, which we'll talk about.
Right. So these type of self-audit programs done under the auspices of an agency, getting their imprimatur, and effectively then having confidence that you're in compliance, you won't be subject to random audits. Obviously, you get an employee complaint, the agency will come forward.
Right.
But there are some things. So it's kind of a reimagining how we've thought about the Labor Department as a directly always adversarial in the last 4 years. They have pivoted in that direction.
That's quite true.
Yeah. Well, Bert, let's move to some agencies that perhaps aren't as clear. How about the Labor Board?
I thought I'd have an opportunity to talk in the past tense, but I am continuing to talk in the future conditional. But the NLRB, we go to the next slide. Well, we are still waiting for the Senate to confirm Crystal Carey as general counsel and Scott Mayer and James Murphy as new members of the NLRB to return the NLRB to a functioning entity with a quorum and a new general counsel. They have all been approved by the Senate Health Committee. They are all queued up, teed up, ready to be voted on. We thought this would have happened, frankly, weeks ago. We thought it would happen certainly last week. We believe it has to happen this week because the Senate will probably go out for the Christmas holiday. The session will end, and if they are not confirmed during this session, their nominations will have to be renewed. We're back to square one. This is one of the key examples for many of us of, frankly, a dysfunctional Congress, dysfunctional Senate. This is not a hard job. These are voice votes. But let's talk about future conditional. Assume that these folks who are all, off the shelf Republicans, supporters of the administration who should be nominated and confirmed and believe we will be. So let's assume they will be. The new general counsel, who of course in the NLRB world is the single most important person, because she, in this case, Ms. Carey, can act without a vote, without a case. She can change the many memoranda that were issued under the Biden board by General Counsel Abruzza. The acting general counsel has already begun that task, but all of the memoranda issued during the Biden administration are going to be withdrawn and supplanted with what looks like the law in 2020. And it will be a much more employer-friendly. The quickie election laws, insofar as they can be revised, will be. There will be a concerted effort to reverse some of the more precedent-breaking precedents of the Abruzzo board. Chief among them, just to take a handful, Chemex, which is the law that dictates very quick, like 2-week elections. Thrive, which creates consequential and compensatory damages for unfair labor practices. Stericycle is one of the many cases that dictate work conduct and handbooks. All of those and many others are queued up to be reversed, but that's a time-consuming process because the board has to wait for a case to come up to give them an opportunity to challenge it. And the board is known for how slow and hidebound its process is. Unfair labor practice before a local regional director, before a 3-person panel or a 5-person panel. And that's the way you get a precedent change. And let's go to the next interesting bullet. In the past, in the tradition of the NLRB, and it's only been a tradition, is that you need 3 votes to change a precedent. Even with the confirmation of the pending new members, there will only be a 3-member board. Will they change the tradition? Will they change anyway? You know, as a functional matter, if a case is overturned, is it really overturned, or will a 4th member be named? Hard to know. They've had enough trouble getting these 2 fellows through. It's hard to imagine they'll try to get a 4th. But if you recall, under the Biden administration, there was a 4-member board with 3 Democrats, which ensured that every 3-member panel, no matter how randomly chosen, would always have 2 Republicans. And that way,
2 Democrats.
2 Democrats, which meant that a decision in concert with the Biden administration's views would always come out. The Trump administration may follow that pattern.
Yeah, I mean, you know, Dave Purdy is the one lone, he's the sole member of the board, has been for months now, and since August, and you know, who knows, maybe he would quit just to destroy the quorum, or, you know, but and I think this question of whether you need a 4th member, I think the board will run over that like a speed bump, and the desire to get these precedents reversed.
Exactly.
Yeah. But what about some of these other litigation claims?
Yeah, how about next slide? We go to the NLRB has been the tip of the spear for the Trump administration's efforts under the unified executive theory to appoint all members of all executive agencies. And the case was just argued last week, called Slaughter versus the FTC, FTC versus Trump. We believe that the Supreme Court indicated that it will turn the final page on this issue, and all members of executive agencies, including leaders of multi-member bipartisan agencies, will become at-will employees. The Supreme Court will permit the termination of all of those folks, and all we're waiting for really is to learn the breadth of the Supreme Court's decision. Will they require the members be appointed? Will they double down on a case called Collins v. Yellen, where they said if you're statutorily appointed, you can continue serving even though there's an unconstitutional provision in the NLRA? Will the court decide that, no, wait a minute, we can't blue pencil the act of Congress, we have to go back to Congress to have them fix it? All of these things remain and will question the continued viability not only of the NLRB, but of all executive agencies. There are other cases to watch. California, Massachusetts have challenged the board, or challenged the primacy of the board by passing legislation that gave the states the right to certify elections, listen to unfair labor practices. Those will probably be mooted if there is a functioning board, because the rationale for those cases, and to upset the strong preemption of the National Labor Relations Act, was that the board was not functioning.
New York they just mooted. They just said New York can't do that.
Well, the courts have said that, but
We'll see
they may pursue. States are being very active. We'll get to states for the rest of this conversation, I think. Finally, the circuit courts are now finally deciding some of the major cases that were passed under the Biden board. Most of them are overturning those decisions. But for those of you not familiar, a couple of the major agencies of the federal government, specifically the Internal Revenue Service and the National Labor Relations Board, do not acquiesce to the rulings of a circuit court, which means they do not accept it as a national rule. They will only recognize it as the law in that circuit. And all that does, of course, is to create more chaotic forum shopping, creates uncertainty, creates instability. If you're a national company, as many of our listeners are, you can imagine the difficulty it has to run a meaningful labor management relations if the law is different circuit to circuit. So we wait now to see exactly what's going to happen. We're waiting on the Senate, like most other people are, and then the board will begin its course to try to remake itself as a reformulated functioning agency.
Next slide.
It's just clear as we go off this, the backlog budget issues. But I think that the question that is increasingly employer, we very well may just have, whether it's EEOC, the NLRB, these other commissions that have traditionally been bipartisan, Republican and Democrat members, staffed with majority of the party controlling the executive branch. They may just be staffed by one party. Most of the statutes don't require this. It's not clear. Who knows if you have to have a full complement? Maybe we just have 3 Republican and NLRB board members. And bluntly, unless and until Congress puts its oar back in the water, this is just going to be a push-pull between the courts and the parties, and people stumbling forward with the states sort of trying to fill in the gaps. It will be chaotic even after the court decides, and assuming that they allow these terminations, which I think, Bert, as you suggested, is clearly more likely than not.
There's one other thing I'd like to point to this last bullet. Until now, every decision of a regional director or a lower ALJ of the board has a right to appeal to the National Labor Relations Board. And many litigants have said, well, you can't enforce this since I haven't exhausted my right. If we have a functioning board, we will again have decisions, meaningful decisions from the regional directors and the lower ALJs in the NLRB. And that's very important for both employers and unions and for the counselors to both.
So, David, back to you. Let's talk about DOJ.
Yeah. So let's just spend a moment on this, because DOJ, for most private employers, is not necessarily has not historically been a primary agency, but clearly in this administration it is. Sarah, let's just jump into the next slide. And that's really because of these new certification requirements. We know we've talked a lot up to this point. I think most people are familiar with the executive order generally imposing a certification requirement. And basically, for all federal contractors, the certification as required in the executive order was that every contract and every grant, there would be a term that requires a party to certify that they're in compliance with the anti-discrimination laws, the federal anti-discrimination laws, and that it does not operate any programs that DEI programs that violate those laws. Now, typically, when that sort of government contracting requirement is put in place, there's a standard certification clause. The federal acquisition regulations, or the defense federal acquisition regulations, the FAR, the DFAR, and so forth, are all amended and conform and implement those changes. That's kind of the normal rules of order. Where are we in the Trump administration? 11 months in. We're not following those. Well, we're sort of following those. Back in April, and it is back in April, I mean, that's eight plus months ago now, the administration said, well, we're going to amend the FAR based on this new certification requirement. And we're going to do so by implementing an interim final. And that's not an unprecedented, but it's a somewhat unusual step whereby the administration goes to a final regulation immediately. They don't show the proposed reg for comment. They just say, we're going to do something final. There have been opportunities to comment through the White House, the OMB. We have participated in this process on this proposed rule multiple times in the last 8 months, putting our oar in the water on how this should be handled. And interestingly, the OMB keeps rolling it over. Yeah. So what we've experienced is this flurry of there were requirements and then there weren't. The State Department had some. They'd email them. It was very chaotic. We still don't have a new FAR rule, number one. Number two, we have litigation. Of course, there's litigation on every development we mentioned, but we have the district courts in both Maryland and Illinois that are ruling on these issues. It is this area of compliance and certification is very uneven, and it varies a lot by agencies. We've had clients that have enjoyed good success by simply asking the contracting official, can you show me where the FAR requirement? I'm happy to certify. Where's the FAR requirement? We do that. And of course, there is no FAR requirement. That sometimes shuts it down. But I think that that's one that is worthy of note, that the Justice Department is very involved in. There's also, next slide, disparate impact. And I think we have touched on that. We've mentioned before that Title VII statutorily contains it. The administration is taking the position it's de-emphasized enforcing it, and that's across the board.
Well, let me just add, many people don't realize that Title VI does not include the requirement for disparate impact. So this is a change that they can make by interim final.
That's correct, Bert.
And
but they've now aligned the interpretation of Title VII, which includes statutory impact, and Title VI, which had been judicially read in, so that they are aligned.
The only big difference that people should be aware of, there is no private right of action under Title VI. So this is a significant diminution of the government's willingness to protect protected groups from discrimination.
Right. So issues for employers on this. Obviously, those that are contractors, grantees, you must stay abreast of these new certification requirements. I don't know when they're coming out. I've given up guessing. They keep rolling it over 30, 45 days, and they keep rolling it over. There's no limit as to how long they can continue doing that. I would have thought that would have been done, but we don't know. The Attorney General, and we've discussed this at some length in some of our earlier webinars and podcasts, issued the July 29th memorandum dealing with what constitutes illegal DEI and proxy discrimination, to Nita's point. Can't just change the nomenclature. You have to actually change your practices in order to lower your risk. But understanding the risks, and with respect to False Claims Act, FCA actions, as we call them, is critical and is an essential part of any well-counseled employer's compliance going forward. And finally, forget what the federal government's doing on impact. Plaintiffs' counsel, boy, when we talk to plaintiffs' counsel, they're all over it. And even when the EEOC dropped the Sheets case up in Pennsylvania, which was an impact case on arrest records and criminal records, the private firm, the Out and Golden firm, I believe, stepped right up and said, sure, we'll take it, and we'll just continue it. And they've made some very public statements, a number of the major plaintiffs' firms saying
that they're looking for opportunities.
We're going to continue it, and we're going to hold strong on this.
I also want to add that we are a Washington-based firm that mainly deals in federal law. You folks have to be very aware that states are very active in this area, and many states, especially the ones with the largest populations, have not retreated on these disparate impact laws, have not retreated on the Title VI-ish laws, and you must be aware of what your state requires of employers and employees, unions and management. It's become very, very, very significant, and it's kind of a disintegration of what we thought was a unified federal system.
Mm-hmm.
Agreed.
Well, I think, David, we want to go to the next slide and spend just, maybe about 10-ish minutes kind of working through additional practical steps that we think are really important. And so did you want to kick us off, David?
Sure, I'd be happy to. And certainly we have, with many clients, spent a lot of energy on these first 2 points that I think are really kind of bundled and part of an effort. But I think there needs to be recognition that, putting aside the debate about whether the prior DEI programs were, quote, illegal DEI, and most of them that we've seen, frankly, were not illegal DEI, but nonetheless, many employers have paused, thought about how they want to present those, that thinking through and assessing what's there is being done with the benefit of an attorney-privileged audit, pretty comprehensive. And a lot of this occurred after the Harvard decision, Students for Fair Admission case. There was an initial decision. I think the well-counseled employers, certainly in the first 90 days, 120 days of the Trump administration, took a fresh look in light of the guidance. We have a number of clients that, in light of Attorney General Bondi's July 29 memo, took a further, more refined look because they have not been terribly clear. although I think that General Bondi's been clear. I think that Chair Lucas has been clear.
Yeah.
I think we know what the administration understands or claims to be illegal DEI. Whether we agree with that or not, many companies have decided we want to lower our risk. So if there's some practices that we can change without conceding that what we were doing was improper before, we're going to consider changing them. And we've had a variety in many industries, sectors that have done just that. And that gets into the updated practices and how that's done. And I would just say one practice pointer, and this kind of goes all the way back to a point we mentioned earlier about Chair Lucas having a very long memory back to 2020. Yeah. One of the standard things that we advise our clients to do is we do scrape their historical website postings, because what we have learned is that the government agencies, that's what they do. They go back and they're out there on the website.
Exactly.
And there is no forgetting. And so we make sure we can explain what may have been posted in 2021, when we changed, why we changed, how the program worked, why we're changing now. Some of those that are federal contractors and so forth have it for purposes of the certification, but it's a fairly nuanced set of efforts. But I think it's one that certainly anyone that is a significant recipient of federal funds, contracts, grants, this I would put as a top priority item.
You know, one of the things that came up recently, and I just saw an executive order where President Trump is going down. One of the reasons that there was a lot of DE&I information on websites, you know, was that they were following various rules of these proxy organizations saying, these are the things you should be doing to increase the number of women and minorities in your workforce and all this. And now the government's going to go after them. And so employers need to be extremely careful around that.
One other thing, it's just one word in the first bullet. That's the word state. And Bert talked quite a bit about that. I had a very interesting conversation with him the last week. Some of the leaders from the U.S. Chamber of Commerce, CHRO, Chief Human Resource Organization officials, and in asking them the question, what are your members most worried about as they move into the first quarter? And interestingly, representing thousands of employers, state law developments stating that the largest, most sophisticated members were really having trouble keeping abreast and getting themselves locked in, because to Bert's earlier point, the landscape is no longer this uniform layout of federal standards, generally with some one-offs, California problems and so forth. It's no longer like that. It's much more, I call it lumpier, the landscape, the compliance landscape. I think that is a huge point. And again, the monitoring of developments, auditing privilege basis, and continual refinement on your compliance is essential. This is not one and done.
Well, and this is more is going to happen. I mean, now that they're seeing, you know, especially bluish and purplish states are going to be more likely to try to step in, especially if they eliminate the EEO1 report.
That's right. Let me start the discussion on the next bullet point about collecting data. It's something we've talked about. We continue to recommend that employers collect the kind of data they did in the past, but with a caveat. We don't want you to share it quite as widely as you have in the past. Treat this information, which we believe is vital to protecting yourself and defending yourself from those state lawsuits, from those private sector suits, if not from the EEOC. We think it's important that you keep the data, treat it like a trade secret. There should be limited access to the data. Don't put it on your website for the very reason that David and Nita have just talked about, that makes it public information. But we think that the data is important for you to protect yourself, for you to understand your own internal processes. We want you to review the data. We want you to analyze the data, but we want you to keep it close.
And specifically by close, HR and legal. These data collections should be done under attorney privilege bases. It should, in consultation with HR, do the appropriate analytics to confirm that your programs are operating in a non-discriminatory fashion, make appropriate adjustments, and that's basically it.
Well, we can confirm that we now have from Chair Lucas, as well as former OFCCP Director Eschbach, that you should collect the data, you should analyze the data, and then
Right.
use it and share it in a very limited fashion.
Agreed.
Well, and okay, so the other problem is that I'm not sure everybody has come to understand that the landscape around DE&I in particular has changed completely. Changing the names is not going to be enough. Remember, they're not going to let you memory hole what you've done in the past. So you need to make aware management at the highest levels, and get your training out there so people understand that decisions. And oh, by the way, can I just say, decisions is always of hiring and all this other stuff. You were never allowed to make decisions based on race and sex. And if employers were doing that, they were violating Title VII. Remember, with Muldrow, that expands the universe of potential lawsuits to many other things, like being chosen for training or, other things that you wouldn't otherwise think about. So you need to get the training out there, get management to understand what the rules are, and so that you don't end up with a problem.
Yeah, if I could just put a footnote to that, the area to be concerned about now includes stuff that you never came to the front of mind. Matters of transfers without loss of pay, for example, the Muldrow situation, the kind of promotion, the kind of training, the kind of career path. There's unusual cases coming up on stuff that used to be the kind of chaff of HR life are now matters of lawsuits. So you have to really expand your training to understand the sensitivity that the government is now bringing to bear that permits situations like that growing into vexing and expensive lawsuits.
And it could be used, we can see where this is going to go. These could be used for False Claims Act whistleblower cases, sure, which we've talked about other times, but would be hugely problematic.
Sure. Well, I think we've already really touched on the state and local workplace compliance. That's probably one of the newer areas that in the last 90 days has accelerated, and I don't think has received enough oxygen. The whole focus has been on the kind of the chaos of Trump 2.0 and all the agencies, but that's something, and every indication is that those developments are coming on much stronger, and in Q1, Q2 will be there. Well, let me just say one other thing as we close out, because I know we're close on time, just in terms of other resources to help you. We do have a resource page on the website. The podcast, we get lots of feedback. By the way, we get lots of great ideas from many of our listeners on topics to cover. I would encourage you, please get in touch with us on that. We do try to have guests from the government come on whenever they're willing to do so. So we try to keep a pretty regular flow of that, as well as just issues that we're seeing day in and day out. So we appreciate the support we've received from so many of you for the podcast. We're going to keep at that. And we really appreciate the support we've received on this compliance series.
Yes.
And I want to thank particularly Bert, Nita, for a really, I think, very informative, very enjoyable fourth and final presentation here. So thank you.
Pleasure to be with you.
All right, Sarah, I see you're on. That means we must be out of time.
That is correct. We would like to thank you all for joining us today. If you have any further questions, please email us at info@FortneyScott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.
Yeah. So best wishes for the holidays, everyone, too.
Merry Christmas, Happy New Year.
We'll be in touch in the new year.